Well, it's 3 o'clock. I say let's get started. So, good afternoon, everyone, and welcome to our first virtual College of Liberal Arts faculty colloquium of the fall 2021 semester. My name is Quentin Maynard. I will be the moderator for today's talk and for each of the talks this semester. Before we begin, I would like to make a few comments. First, we are recording this session. We were hoping to stream it live on Facebook, but we were unable to do that this time. If you have any questions for the speaker, there is a Q&A button down at the bottom. You can type your questions there, and we have some time dedicated to that at the end, and we'll have Dr. Jalain answer the questions then. If we have any students in the audience who wish to receive extra credit for attending today's talk, please send me a message via the chat stating your name, your professor's name, and the course for which you'd like to receive the extra credit. So without further delay, it's my pleasure to introduce today's speaker. I can't speak apparently. Dr. Caroline Jalain. Dr. Jalain is an assistant professor in the Department of Criminal Justice. Dr. Jalain graduated with her PhD in criminal justice from the University of Louisville in May 2020. She received her master's in criminal justice from the University of Southern Mississippi and her bachelor's from the University of Orleans in France. She also has a Master of Law from La Sorbonne in Paris. Caroline's research focuses on courts, specialty courts and fear of crime using international data. Her passion is teaching USI students about the court system and courtroom actors along with criminal law and criminal procedure. Dr. Jalain, the screen is yours.
Well, thank you so much, Quentin. I love how you say my name. That was awesome. I really loved it. Thank you. All right. Good afternoon, everyone. Thank you so very much for being here today. As Quentin said, my name is Caroline Jalain. I'm an assistant professor in criminal justice here at USI, and I'm very excited to present the results of my research. But before I do, I would like to thank the College of Liberal Arts for granting me a faculty development award. That money allowed me to hire a student. Her name is Emily Simmons, and she participated in this research project with me. I would also like to thank my co-authors, Dr. George Higgins and Dr. Viviana Andrescu from the University of Louisville, for helping me shape the project and run the analyses. I would also like to thank my colleagues from the Criminal Justice Department for their unconditional support in everything that I do. So thank you to all of you. As Quentin said, my research agenda focuses on courts, specialty courts, and lawyers. And as I taught some of the courts classes here at USI, my students and I have had very interesting conversations over criminal justice actors who have a lot of power and a lot of discretion, and one of them being the prosecutor. So from starting an investigation to pressing charges, offering a plea deal, all the way through the sentencing phase, prosecutors participate in every phase of a criminal case. So today I am presenting Punishing the Powerful, a study of prosecutorial misconduct in the era of ethics of reform. Michael Nifong, Richard Jackson, Thomas Pertler. What do these men have in common? They recently got disbarred because of acts of misconduct. Take Michael Nifong, for example. He was involved in the Duke Lacrosse rape case. For those of you who are not familiar, on March 13, 2006, the Duke Lacrosse team held a party at an off-campus house, and they hired 2 strippers to perform. The following day, one of the dancers, 27-year-old Crystal Mangum, told police in Durham, North Carolina, that 3 white lacrosse players forced her into a bathroom and gang raped her. Within 2 weeks of Crystal's phone call to the police, 81 indictments were in effect. And in the meantime, the story had riveted viewers across the country, and many believed the victim. Duke College officials' responses was, young men, sometimes they just make bad decisions. On March 23rd, the team's 46 white members provided police with DNA samples and were photographed. But only 3 weeks after the allegations surfaced on April 10, defense attorneys revealed that DNA test results from the rape kit did not match any of the Lacrosse players. Nevertheless, Durham County District Attorney Mike Nifong, who labeled the players hooligans, vowed to continue investigating the case. Despite the lack of DNA evidence and despite the fact that he had not interviewed the accuser, he arrested 3 of the Lacrosse players and charged them with rape, sexual offense, and kidnapping. It did come out, however, that when she was 18 years old, the accuser filed a rape claim against 3 different men, raping her when she was 14. But those charges were never brought. So more and more, it seemed that because he was running for DA when the rape allegations were made, Nifong was vouching for his case in ways that most prosecutors don't do, especially not before the investigators have completed their investigation of the case. Meanwhile, all 3 players maintained their innocence. They had cell phone records and timestamp photographs that demonstrated that they could not have committed all the crimes that they were accused of. For example, one of the players was on camera getting money from an ATM at the same time he was supposed to be raping the accuser. But the most troubling evidence came from the woman who was dancing alongside the accuser at the Duke party. She said if a rape occurred, she didn't see it. She said, however, that the accuser wanted it to appear she had been attacked, asking her to put marks on her for her story to be more believable. Despite all of this, Mike Nifong was not backing off. But by December, the prosecution was falling apart. Nifong's old DNA expert punched a huge hole in the case when he testified that he and the district attorney had agreed to withhold DNA evidence from the defense. And it wasn't just that none of the Lacrosse players' DNA had been found in the accuser's rape kit. The DNA of 5 other men was found, and it was not disclosed by the prosecutor, who still maintained that he had done nothing wrong. So Nifong basically asked the biologist, just give me the results that I want to hear. Equally shocking, 9 months into the case, the DA admitted that he still had not interviewed the accuser. But when he did in December, he discovered her story had changed. The accuser said that she now was unable to say whether she'd been raped or not. So in this case, Nifong was heavily criticized for his rush to judgment and his heavy reliance on the faulty testimony of the accuser. He was disbarred in June 2007 and later convicted of criminal contempt for making false or misleading statements to a judge. The 3 accused players received an undisclosed financial settlement from Duke University, and they later filed a lawsuit against Nifong, the city of Durham, and the investigating police officers. So this case is one of many instances of prosecutorial misconduct occurring in the US. And with tremendous impact on people who have been wrongfully accused or have suffered from acts of prosecutorial misconduct, that's the reason why I was attracted to finding out everything I could about it. So what is prosecutorial misconduct? Well, Browning in 2014 defines prosecutorial misconduct as when a prosecutor deliberately engages in dishonest or fraudulent behavior calculated to produce an unjust result. So prosecutorial misconduct occurs in a variety of areas. It could be courtroom misconduct. For example, making inappropriate or inflammatory comments in the presence of the jury. You see this a lot during opening statements when a prosecutor is trying to appeal to the sympathy of the jury by using very highly emotional arguments. This is especially true for cases involving the injury of a child or the wrongful death of a loved one. It could also be introducing or attempting to introduce inadmissible evidence. It could be mishandling physical evidence, such as hiding, destroying, tampering with evidence, tampering with case files, court records. It could also be failing to disclose exculpatory evidence, which is evidence that would absolve the defendant. So for example, fingerprints or DNA on a knife in a murder case that would link the crime to another individual. It could also be threatening or badgering witnesses, using false or misleading evidence, and the list goes on and on and on. So why is studying prosecutorial misconduct important? Well, as a representative of the state, a prosecutor holds an imperative role in the United States criminal justice system. But with great power comes great responsibility, and consequently, prosecutors are able to commit ethical violations in criminal proceedings, oftentimes resulting in prosecutorial misconduct. Therefore, the scales of justice become imbalanced due to prosecutorial misconduct. So within the court system, the issue of wrongdoings perpetrated by state actors, mainly prosecutors, is both prevalent and also underreported. And it goes against what the Constitution is supposed to provide to all individuals, which is a speedy, fair, and impartial trial. So I called this presentation an era of ethics reform because since 2000, efforts advocating for more transparency for the prosecutor have been put in place. Specifically, one reform and two resolutions have been passed to make crystal clear what prosecutors must do and not do when it comes to presenting the evidence they have about a particular case. So the Ethics Commission of 2000 came up with a reform requiring a prosecutor to make a timely disclosure to the defense of all evidence or information known to the prosecutor that can negate the guilt of the accused or mitigates the offense or be useful during sentencing. So that's the 2000 reform. In 2010, with the resolution 102D, the resolution urged federal, state, local, and territorial courts to adopt a procedure where a criminal trial court must conduct a conference at a reasonable time prior to a criminal trial with prosecutor and defense to ensure that they're fully aware of their respective disclosure obligations and to also offer the court's assistance in resolving disputes that can happen over disclosure obligations. Fast forward a year later, the resolution 105D said that governments needed to adopt and codify disclosure rules in court. So those disclosures were very much related to what the Ethics Commission's requirement were back in 2000. Basically saying the prosecution needs to make timely disclosure to the defense before the commencement of trial or before a guilty plea is happening, of all information to the prosecution that could negate the guilt of the accused, mitigate the offense, impeach the prosecution's witnesses, or any evidence that can impact the sentencing process. So with these resolutions in place, my question was, have things changed since there are clearer guidelines for prosecutors about what they need to do when it comes to sharing information they have about a case? So using the Center for Prosecutor Integrity data, I had my student Emily import that data into an Excel spreadsheet and then into SPSS. We recorded 1,054 cases of prosecutorial misconduct across the United States between 1978 and 2013. So from the graph, we can see that 4 major activity peaks for prosecutorial misconduct between 1978 and 2013 occurred. One occurred in 1990, one around 2002, 2003, one in 2005, and then one in 2008, with a number of prosecutorial violations going from 0 in the late 1970s to almost 40 instances of misconduct per year in the early 2000s. So to have a better idea of the distribution of those prosecutorial misconduct, let's look at another diagram. So I have separated our time frame into 3 categories, one corresponding to before the Ethics Commission of 2000, one between the Ethics Commission and the first resolution of 2010, and one to match the time frame after the resolution of 2011. And so the diagram shows that between 1978 and 2000, there was an average of almost 16 acts of misconduct per year. After the Ethics Commission, that number doubled from 16 to 32 instances per year on average. And after 2010, this number went down to 6 instances of misconduct per year on average. So as I mentioned a minute ago, acts of misconduct can occur at different times during the trial. One act of misconduct that is of particular importance is called a Brady violation. It is a pre-trial violation, so before the trial starts. The Brady rule was named after Brady versus Maryland, a case that occurred in 1963, and it requires prosecutors to disclose materially exculpatory evidence in the government's possession to the defense. So this Brady material or Brady evidence includes any evidence favorable to the accused. It can be things like evidence that goes toward negating a defendant's guilt, evidence that would reduce a defendant's potential sentence, or evidence going to the credibility of a witness. So the verbiage of the Brady rule is very similar to the verbiage in the Ethics Commission's reform and the other 2 resolutions as well. So that's why I'm focusing my analysis on the Brady violations to determine if those had an effect on the defendant's case. So when looking at Brady violations, you can see on the first diagram or the first graph that there are several peaks in 1990, in 2003, 2005, and 2008, with a drastic decrease after 2010. When you look at the second graph, it shows that between 2001 and 2010, so between the Ethics Commission reform and the first resolution, the annual average Brady violations was the highest, with over 7 a year, whereas there were only 4 between 1978 and 2000 and less than 1 between 2011 and 2013. So when looking at the relationship between the Brady violations and types of crime, we see that among cases that registered Brady violations, 4 out of 10 cases involved a violent crime, which I thought was pretty interesting. So what are the consequences of those instances of misconduct for the defendant? Because ultimately that's what we want to know. What happens to a case after we've figured out that misconduct has occurred? Well, looking at the data, prosecutorial misconduct does have an effect on the defendant's case about half of the time. So a defendant who has been wronged because of prosecutorial malfeasance will see their case modified from what it was originally, that is, prior to the act of misconduct being discovered. So in instances where there are effects on the defendant's case, in 23% of the time, remand for a new trial occurs. That is, the court decides to send the case back to the lower court for the defendant to get a brand new trial. This is followed by a reversal or vacation of conviction in almost 14% of the cases, and then dismissal is almost 6% of the cases. And I want to take a second and make sure that I make the distinction between a vacated conviction and a dismissed conviction, because those are a little bit different. A vacated conviction does not count toward the person's record. It's as if the conviction simply vanished. It never happened. A dismissed conviction, on the other hand, did in fact happen. The person may have pled guilty to a crime. So in other words, he or she committed a crime. that subsequently resulted in a conviction. It just so happens that after the conviction, the case got dismissed. So there's a little bit of a distinction here. So after doing the first analysis, I've decided to conduct a second one. And the purpose of the second analysis is to determine what factors differentiate cases that had some impact on the defendant's case versus cases in which prosecutorial misconduct had no repercussions on the case. So for this second analysis, the dependent variable is a dichotomous variable coded 1 if the prosecutorial misconduct had an effect on the defendant's case, and 0 if it didn't. For independent variables, I had trial court, which is if the prosecutorial misconduct was identified early by the original trial court, it was coded 1. If it was identified by a disciplinary body, the Court of Appeals, it's the Supreme Court, it was coded 0. I had Brady rule. If the case involved a violation of the Brady rule, it was coded 1, otherwise it was coded 0. At violent crime, if the case involved a violent crime, including assault, it was coded 1, and then cases with sex, drug-related, and non-violent crimes were coded 0. I had federal cases that were coded 1 and non-federal were coded 0. Number of identified violations, those were the number of identified violations per case, which was a continuous variable ranging from 1 to 6. And then I had cases identified after 2010. So after the first resolution that were coded 1 if it was after 2010 and 0 if it was identified in 2010 or earlier. Make a note though that on the case that were identified after 2010, that variable had 400 cases missing cases. We'll talk about that at the very end. So in almost half of the cases, when looking at descriptive statistics, you see that if the prosecutorial misconduct was identified, it affected the defendant's case. Only in 10% of the cases was the misconduct identified during the original trial in the lower court. You also see that 51% of cases having an effect on the defendant's case were for violent crimes. You see that about almost 14% of cases were identified after the passing of the first resolution, so in 2011 or later. In 18% of the cases, a Brady violation had been committed by prosecutors. And on average, prosecutors committed more than one act of misconduct. And in 14% of cases, those acts of misconduct occurred for federal cases, so cases in federal court. So apologies for the correlation matrix being very small. That's the only way I can make it fit on the PowerPoint slide. So hopefully you can see with me. The correlation matrix is here to determine how much variance the measures share. So this table shows that all measures share variance, with the majority being weak and positive, except for number of misconduct, violent crime, and misconduct identified in 2011 or later, which have a weak but negative correlation. So I want to talk about a couple of interesting findings from this correlation matrix. If the misconduct is identified by the trial court, an effect on the defendant's case is significantly more likely to be present than they are if the identifying body is a disciplinary body, the appellate court, or Supreme Court. But as the number of misconduct acts committed increases, the more likely it is to be caught by an appeals court or Supreme Court or disciplinary body and not a trial court, which I thought was pretty interesting. As the numbers go up, then the likelihood of it being found by the trial court goes down. Also, as cases of misconduct occur after 2010, they're less likely to have an impact on the defendant's case. They're also less likely to be identified by a trial court and less likely to be federal cases. But again, these correlation coefficients are very, very small. So from the correlation matrix, we saw earlier that if the case involved a violent crime, prosecutorial misconduct is less likely to have an effect on the defendant's case. But when controlling for the other variables in the equation, the effect is not statistically significant anymore. Also, when prosecutors commit violations in federal cases, their misconduct is more likely to have an impact on the defendant's case than it happens when the case is non-federal. If the case involves a violation of the Brady rule, the odds of having an effect on the defendant's case are 3.6 times higher than they are for cases that have other types of misconduct. Another interesting fact: the odds of observing some effect on the defendant's case increase by a factor of 2.13 with each prosecutorial violation. You can also see that cases of misconduct that are identified post-2010 are less likely to have a positive result for the defendant than cases identified earlier, but the effect is no longer significant when other variables enter the equation, which is a little disappointing. But when we look at the R-square, we see that almost 30% of the dependent variable, which again is the misconduct having an effect on the defendant's case, is explained by the independent variables in the regression model. So what have we learned from all of this? Well, cases of misconduct increased after the passing of the Ethics Commission reforms, but decreased after the 2010 and 2000 resolutions. While half of the cases where prosecutorial misconduct was found were, let me back up. Half of the cases where prosecutorial misconduct was found were not affected. The other half were, and the most significant effect were remand for a new trial and reversal or vacation of sentence. When we looked specifically at Brady violations, the average commission of acts of misconduct increased between 2001 and 2010, and then decreased after 2011, with a majority, which was 43%, being for cases involving violent crimes. What was important to me, though, was finding out the characteristics of cases that were in fact affected by prosecutorial misconduct. And so results show that the defendant's case is more likely to see a change when prosecutors commit misconduct in federal cases, if the misconduct type is a Brady violation, and if the prosecutors commit more than one act of misconduct. So while the number of prosecutorial misconduct cases decreased after the passing of the Ethics Commission reform and the two resolutions, especially after 2010, we noticed that, in 50% of the cases, nothing happens to the defendant's case after misconduct is found. And so to me, this is unacceptable. This is a very unacceptable number, considering the number of people who have been wrongfully convicted due to prosecutorial misconduct. For example, the Innocence Project found that 65 of the first 255 DNA exonerees raised allegations of prosecutorial misconduct in their appeals or in civil suits that were filed after exoneration. With that being said, though, one of the limitations of this research is the amount of missing data. For a lot of cases, the trial year was missing or the finding year was missing, but what was missing the most was data about sanctions. Out of the 1,054 cases that we had, only 24 reported a sanction being attributed to the prosecutor. Of those 24, 2 were sent to training as punishment, 6 were suspended, 4 were disbarred, and for the other 6, it said other. So why are prosecutors not punished? Well, under the current United States Supreme Court precedent, prosecutors are frequently granted immunity from civil lawsuits, meaning that they cannot be sued by a wrongly convicted person. even when they intentionally violated the law. So they have that protection. In addition, it is very difficult to find proof of misconduct that is designed to, well, stay hidden, especially when prosecutors hold so much power to control access to what's in their files and to witnesses. And then lastly, when prosecutorial misconduct is in fact found, the bar discipline committees that are charged with the investigation or were investigating these cases are often overwhelmed with other cases. They lack expertise in criminal law. They follow codes of ethics that are very vague. And in some cases, they're biased in favor of prosecutors and give them every benefit of the doubt. So what should we do? Well, the lack of sanctioning for prosecutors and a lack of effect on the defendant's case when misconduct is identified is making oversight by public agencies and the courts all the more critical. So one recommendation that I have is to ask states to experiment with new systems that would be devoted to the particular duties of prosecutors. Maybe creating a prosecutorial conduct commissions or court orders for compliance with discovery rules, which is what's happening in New York City right now. They're called Brady orders. So those are a couple of suggestions to really tap into this idea that because 50% of the cases where misconduct occurs does not have any impact on the defendant's case, we probably need to do things a little bit differently. And that is all I have. Thank you for watching. I can't hear you, Quentin.
I muted myself. My apologies. Well, thank you, Dr. Jalain. If anyone has any questions, feel free to send it to us in the question and answer panel or in the chat. I don't have any at this point. I guess I'll give everyone a couple seconds to type something up, but that was very interesting.
Well, thank you.
Someone says, thank you, Dr. Jalain. I enjoyed your presentation.
Oh, well, thank you.
Anything else? I got like 15 chat windows open. I'm just trying to make sure. Okay, we have one question. Did you see an increase in misconduct cases during election years?
Ooh, that's a good question. So let me pull up the graph. Okay. So yes and no. The reason, I don't know if it's a reason, but it fluctuated a lot between 2000 and 2010. So it probably had something to do with the election, but I think what it had to do the most is a lot more exposure to the idea of prosecutorial misconduct. It came to light with these cases of prosecutors being caught, you know, a few years after some of the cases were brought to light, you know, so I think it may have had something to do with elections, but nobody who has been a candidate lately has brought up the idea of prosecutorial misconduct, just because, you know, they're representing the state, they're representing the government. And so we're a lot less likely to punish these people. I was actually reading judges' interviews who were pretty much advocating for the fact that if they need to punish somebody, they'll do it within their courtroom, and we really don't need to have any sort of say about what prosecutors are doing. So to answer your question, Justin, it may have had an impact, but if it was minimal, just because nobody has really brought it up in their campaign or in the way that they want to change things. I think they're a little bit more comfortable with the way that things are being done, especially because prosecutors work for the state, they work for the government. So why would we want to punish them?
Great. So we have another question. It says, what are the steps that need to be taken to ensure that prosecutorial misconduct go down?
What are the steps that need to be taken to ensure that prosecutorial misconduct go down? I think we have to have a little bit more accountability when it comes to things like this. The problem with prosecutorial misconduct is underreporting. So I had a reporting variable in my data set, before it's even identified in court, for someone to really report that prosecutor and say, well, no, that person entered falsified evidence into court, for example. And unfortunately, that variable was part of my bazillion variables that had a lot of missing data, and I couldn't do anything about it. So it would have been nice to look at how much of it was reported versus how much of it was discovered while the trial was still going on or on appeals. So I think, to answer your question, Anna, the steps would just have to come from the government telling its own representative, its own people, the people that work to represent it, to be more mindful when they decide to withhold evidence, not share evidence, and not allocate so much importance to having a case, having somebody in prison, feeling like you have one more win today because you sent somebody to jail. I think the way that our prosecutors are selected through elections has a lot to do with how much of a win they want, how much they want on their board saying, I prosecuted this many people, you need to re-elect me. I think if we were to change the way that these people come into the job, that would have an impact on a little bit more of rule following rather than bending the rules to make it fit their agenda.
Great. The next question, I'm trying to go in order as they came. It says, was this a great presentation? Was this a binomial I can't speak right now. Binomial logistic regression? If so, have you considered multinomial to separate out the effects on the case? I think it'd be really fascinating to see the impact on various effects.
So when I ran the analysis, I ended up having I'm losing my train of thought. Hold on, Laura. I know what I'm trying to say. Yes, so it was binomial logistic regression, and I have, so for the sake of this presentation, I didn't show the multinomial separating the effects, but I have a project to divide it by chunk of years. So between the 1970s and the Ethics Commission, and do look at the effects for each kind of chunk of time. So that's a second or third analysis that'll be more multinomial. But for the sake of today's presentation, I felt like binomial were more appropriate, especially because I still want to dig deeper in. I have a problem with the way that they have the data in the data set between the finding year and the trial year, because the trial may have happened in 2001, right, after the Ethics Commission, but it wasn't found until 2013 after the two resolutions. So I want to see how much of that has played a role in it. And again, I have a lot of missing data. So I'm going from 1,054 cases to 650 cases when I really tap into the trial year and the finding year. And so in a second time, and if you want to chime in, you're welcome to tag along. I want to really look at what that looks like. And from preliminary results, it looks like people were better off before those resolutions were passed. Just running preliminary analysis, it looked like the effect on those cases were a lot less after the passing of those resolutions and a lot more before. So all in all, it looked like I have a lot more work to do, but it sounds like these people were a lot better off before those resolutions were passed. Great question.
Great. The next question's in the chat. It says, great talk, Dr. Jalain. Is there any data indicating whether prosecutorial I can't speak. I'm sorry. Prosecutorial oversight is susceptible to political interference.
So I'm not really sure I understand the question, but there is a relationship between prosecutorial oversight and politics. Similar to my answer to Anna's question, because of the way prosecutors are selected to be a part of the job, to be selected to be prosecutors, a lot of times these people run on numbers. And it's very important for them to have all these cases, to bring these cases to court, to adjudicate all these defendants, to send them to jail. People, when they're trying to elect somebody, they respond a lot better to, wow, you put all these people in prison. We feel so much safer now. Thank you. Rather than, yeah, but out of the 165 that you sent to prison last week, how many of those actually didn't do it? Or how many people did you coerce to take a plea? How many people, and so I think, oversight or tweaking cases or reality definitely has a motive of, I'm being watched because in 3 to 5 years, I'll be reelected. I want to make sure that people know that I'm cracking down on the criminals, and I'm hoping, to make people feel safer. So hopefully that answers your question, Vinay.
All right. The next question says, Georgia seems to be really cracking down on prosecutorial misconduct recently, with several cases pending. Any idea why that state in particular is leading in this area?
I'm not sure. If I were to guess, I would say somebody who recently got elected was starting to realize that that was an issue, but I'm not really familiar with Georgia. I do have in my data set prosecutorial misconduct in state, so I can look to see at how many cases of those prosecutorial misconduct occurred in Georgia, and maybe somebody took an interest in it. But that's a great question. I'm not really sure why Georgia, because I know New York, the Innocence Project contacted Cuomo and asked him to really come up with solutions for prosecutorial misconduct when they realized that a lot of those exonerees were accusing prosecutors of misconduct, and it's starting to move in New York. I wasn't aware of Georgia. I have to look into it. I'll make a note of that. Thank you, Kate.
All right. The next one, how many prosecutors have been disbarred in the past few years? Also, amazing presentation. Good job on your research.
Thank you. So if I go by what the data says, and granted, I only have data until 2013, not a lot, right? Remember what I was telling you earlier? We only had a few that were disbarred, a handful of them that were disbarred. If you look at newspaper articles, there are a lot more, which again taps into this idea of missing data and how, the Center for Prosecutor Integrity did a good job putting everything together, but there's a lot that's missing. So ideally, it would be nice to cross-reference what we have with journal articles or publications or news articles to really see what's happening. I would say still not enough to answer your question, because the process of disbarment, the process of getting rid of prosecutor is long, is lengthy, is complicated, and the agency that's in charge of it is a part of the Bar Association, and these people just don't really know what to do or don't want to do it, because it's not something, they want to believe the prosecutor. They don't want to believe that they would want to abuse authority and power. So to answer your question, not enough.
All right, and the last question that we have, it says, do you believe some prosecutors are not punished due to politics or corruption?
I don't think it's corruption. I think it's more so again, the politics of the job, and also just the lack of what do we do with these cases? Eventually, the Bar Association had to come up with a plan, especially when there was pushback from judges saying, well, if I see it, I'll catch it. If it happens in my court, I'll catch it. So I think it's politics, definitely, but it's also just a lack of resources and a lack of, well, there's two things. It's a lack of resources and a lack of training and just too many cases to deal with, but it's also a living life with little blinds on and realizing that no, it's not happening. It can't be happening. No, why would people that have so much power abuse it? We talk about prosecutors, but judges too. There are instances of judges misconduct, and that happens. You don't really hear it a lot, but it does happen. So to answer your question, corruption, probably not. Politics, definitely.
All right, and I have no more questions, so I'd like to, Dr. Jalain, thank you so much for this wonderful and interesting presentation. Everyone else who's here, thank you for coming. This was our first of the semester, and I think it went really well. Our next talk will be on October 15th by Dr. Norma Rosas Mayan. The title of her presentation is a presentation of the book, Afro-Hispanic Linguistic Remnants in Mexico, the Case of the Costa Chica Region. So we hope to see you there. And with that, that's the end of today's session. Thank you again for attending, and we look forward to seeing you at the next faculty colloquium. Have a great day, everyone.
Thank you for coming. Thank you, Quentin.
Thank you.
Thank you.